David, is there something that's very misunderstood about workers' compensation? Do you have clients come to you and say, I sprained my ankle and I want workers' compensation? What are some do's and don'ts up front on these kinds of cases?
Well, there's a lot of things that are misunderstood, but I suppose one of the more common things is the concept of, pain. There's no separate award for pain and suffering in a workman's comp case, as there is, say, in an automobile wreck. However, pain can be a factor in making one disabled. It can be a major
Absolutely.
factor. So, in that sense, it's important. But as far as a separate award for pain and suffering, there is none.
Is that because it's so hard to prove to a judge or a jury, or why has it become that way? You would think pain would be as much of a factor in a job injury as a car wreck. Well,
I think the short and long of that is simply that it wasn't set up that way.
Okay.
Everything about workman's comp is statutory. It's all in the code, in the code of Alabama, and it's just not provided for. I think that's the short and long of it.
It's a trade-off.
Yeah, whereas
you don't get that, but you get other good things, right?
Exactly, and the good thing, the best thing about workman's compensation, I believe, is the medicals. Now, that's not perfect by no means, but medicals are open forever unless you give it up. Unless the worker gives it up, they're going to get medical treatment for the rest of their life, whether it's hospital stays, MRIs, CAT scans, medication, therapy, and mileage for going to their doctor.
Related to that injury, not something else that's unrelated.
It's not a health insurance plan. It's related to that injury.
If you hurt your back on the job and that's proven to be a workers' comp claim that's successful, that treatment would always be provided.
Another great one is I have to prove liability. I have to prove fault. Dave, I don't think you have to, do you? Just prove it on the job.
That's exactly right. That's a major thing. Even if you're contributory negligent, the worker dropped the ball and did something stupid and got hurt, he's going to recover unless the reason he got hurt was because he was impaired by drugs or alcohol.
What if
Otherwise, he's going to win his case.
So if you're drunk on the job, that's a whole different thing. But what if you violate a safety rule? You've been trained how to do this thing safely and you don't do it. You said it was stupid. I guess that's what it is. Still violating a safety rule, you might be rewarded compensation.
Well, if he wasn't impaired by drugs or alcohol, then he still recovers.
Because we all make mistakes. We all goof up.
He made a simple mistake.
But that doesn't prohibit him from being successful with his claim.
That's right. Only if he was impaired by drugs, alcohol, or some sort of misconduct.